Okay friends, in this video we'll be discussing important MCQs on Muslim law. These questions will be very important for LLB students. So let's start. First, a marriage of a Muslim with a woman prohibited by reason of affinity shall be irregular, void, valid, or none of the above. Woman prohibited by reason of affinity. It should be void. There are restrictions on Muslim men while carrying out marriages. There are some prohibitions, with regard to blood relations. A person cannot marry on the grounds of affinity, and the relations of affinity, that is the descendants or the ascendants of his wife. So if a Muslim marries a woman who is prohibited by reason of affinity, that is, who is a member of either descendants or ascendants of his wife, this would be void at the first tense. It is void marriage. With whom a Shia Muslim man is entitled to perform a temporary marriage, that is muta, Muslim woman, Christian woman, Jewish or a fire worshipping woman, any of the women stated above. A Shia Muslim can marry for this sake of this temporary marriage, that is muta, which is not precedent in India, or neither it is available in this form. So this Shia Muslim can marry any of the women stated above. It is not mandatory that the woman should be Muslim. The woman may be of Christian or Jewish or fire worshipping woman. So Shia community and the Muslim may perform this temporary marriage, that is muta, with any of the women, either she is Muslim, Christian, Jewish, or she is worshipping fire. Any of the women stated above is the correct answer. This muta marriage was earlier accepted in the Shia factions of this Muslim. However, this is not relevant in India. Next question. The provision of Dissolution of Marriage Act 1939 give right to judicial divorce to husband only, wife only, both husband and wife, and none of the above. See, the Dissolution of Muslim Marriage Act 1932, it gives right to wife only. It doesn't give right to husband. It gives right to wife only. It was enacted in the year 1939 on 17th of March. It gives right or the provisions of dissolution of marriage to the wife only. Dower is a mark of respect to the wife, a consideration to the marriage, an essential incidence of marriage, or all of the above. It is all of the above. It is a mark of respect to the wife, yes, a consideration to the marriage. This consideration is paid to the wife by the husband, and it is an essential condition of marriage in Muslim marriages. So all of the above is the correct answer. According to Shia law, to execute a marriage, presence of witnesses not necessary, required two witnesses, required male witnesses. It is the requirement of witness is necessary. It is a valid requisite, is a valid condition of Muslim marriage. That the acceptance offer and the acceptance should be done at the same sitting and at the same place with the presence of witness. So it is a necessary condition. Which of the following is a requisite for a valid marriage under Muslim law? Consanguinity, affinity, proposal and acceptance at the time of marriage, or stress. See, requisite for a valid marriage. If a person is marrying another person who is related to him or her with this consanguinity, affinity, and fosterage, all this becomes void. This becomes void at the first tense. So the requisite for a valid marriage is this, that the proposal and the acceptance at the time of marriage is the correct one. Proposal and acceptance should be there, and at the time of marriage and at the same seating or at the same place. Essential requirements of a Muslim marriage are qubul only, ijab only, both qubul and ijab, none of these. The essential requirement of a Muslim marriage is both qubul and ijab. This is qubul is acceptance and ijab is the offer. The offer is called the ijab and qubul is called the acceptance. So offer and acceptance both are the essential requirements of a Muslim marriage. A Shia Muslim already having 4 wives has contracted a 5th marriage. The 5th marriage is valid, voidable, void, or irregular. A Muslim already having 4 wives has contracted a 5th marriage. The 5th marriage is valid, voidable, void, or irregular. It is irregular. It is irregular. A Muslim can have any number of wives subject to maximum number of 4 wives. Keeping 4 wives at a time is valid, but if he has contracted a marriage with the 5th wife, then the marriage is not void, it is irregular. It is not void, it is irregular. What type of Muslim marriage is which is performed temporarily for enjoyment? Batil, Shahi, Muta, or Fasid. Batil means void, Shahi means valid, and Fasid means irregular. And Muta is the form of marriage which is performed temporarily for enjoyment, and this can be for 1 day, 1 month, 1 year, or whatever the period that is mentioned in the contract. So Muta is the answer. A Sunni Muslim can marry any number of wives not exceeding 4. If a Muslim marries a 5th wife, such marriage shall be irregular, as already covered. It is irregular. Under Muhammadan law, legal incompetency to marriage means minority, unsoundness of mind, both minority as well as unsoundness of mind, only unsoundness of mind and not minority. Under Muhammadan law, legal incompetency to marriage means both minority as well as unsoundness of mind. Both minority as well as unsoundness of mind. If a person is unsound, if a person is of unsound mind, he cannot provide consent. That's why he cannot marry. Therefore, it is legal incompetency. And both minority is also a form of legal incompetency to marriage in Muslim law. Marriage in a Muslim law is a sacrament, a civil contract, a sacrament and a civil contract both, or a social status. No, it is a civil contract. It is a civil contract. Marriage in Muslim is called nikah, and it is a contract for the legalization of intercourse and the procreation of children. Therefore, it is a civil contract. Which one of the following is not essential for a valid marriage under Muslim law? Offer and acceptance, competent parties, fosterage, free consent. Offer and acceptance is required. Competent parties are also required. Free consent is also required. This one is not required for a valid marriage. However, this is the reason for invalid marriages, that is void marriages. A person cannot enter into marriage with another person who is related to him or her by fosterage. So, fosterage is the correct answer. A man is prohibited to marry his daughter on the ground of affinity, consanguinity, postres, or none of the above. It is prohibited to marry his daughter. A man is prohibited to marry his daughter on the ground of, because they are related with blood. So consanguinity is the correct answer. Sunni Muslims consider muta marriage as void, voidable, valid, or invalid. Sunni Muslim. This muta marriage is valid and accepted by the Shia faction of Muslim. Sunni Muslims, they do not consider it valid. So Sunni Muslim consider muta marriage as void. They do not accept this form of marriage. And the maximum population of our India, they are Sunni. So this form of marriage is not at all precedent in our country. The people of Shia faction of the Muslim accept this as muta marriage. Accept this muta marriage. Sunni people, they do not accept it. So as per Sunni Muslims, muta marriage is void. It is void. Which of the following is not essential for a valid marriage under Muslim law? Is not an essential. This question has been already covered. Postres. Postres is the answer. Iddat is a period during which a Muslim woman is prohibited from marrying on dissolution of marriage. Iddat is a period during which a Muslim woman is prohibited from marrying on dissolution of marriage, either by death or by divorce. Both A and B is the correct answer. If the wife is divorced, the iddat period shall be 3 months. 3 months. And if the Muslim woman is divorced by way of death of husband, then the iddat period shall be 4 months and 10 days. This is the correct answer. Both A and B is the correct answer. In Muslim law, marriage contracted without witness is void, valid, invalid, or irregular. In Muslim law, marriages contracted without witness is void, valid, invalid, or irregular. See, irregular marriages in Muslim marriages are those marriages when the prohibition of the marriages are of temporary basis and they are violated. Okay, it becomes irregular. If the prohibition is violated, which are of temporary nature, then those form of marriage is known as irregular marriages. So in a Muslim law, contracted without witness, that is the temporary prohibition, violation of temporary prohibition, this is irregular form of marriage. In Muslim law, marriage contracted without witness is irregular. For a valid marriage, the witness is required. Presence of the witness is required. So the answer is irregular in this case. The Dissolution of Muslim Marriage Act is based on the following school of Muslim law: Hanafi school, Shafi school, Maliki school, or Zaidi school. The Dissolutions of Muslim Marriage Act 1939 is based on the school of Maliki school. Maliki is the correct answer. Maliki school is known as the Islamic jurisprudence, school of Islamic jurisprudence. So the Dissolution of Muslim Marriage Act 1939 is based on Maliki school. This is the correct answer. Marriage of Muslim male to his maternal uncle's daughter. Marriage of a Muslim man to his maternal, that is mother, maternal uncles, that is brother of mother, and daughter. Uncle's daughter is valid, voidable, void, or irregular. It is a valid marriage. That is, they are not connected by way of blood, nor affinity, nor fosterage. So it is a valid marriage. Children of two sisters can validly marry under which of the following? Muslim law. Children of two sisters under which of the following? Muslim law, the Special Marriage Act 1954, the Foreign Marriage Act 1969, or the Parsi Marriage and Divorce Act 1936. It is the Muslim law. Two sisters, children, they can marry because they are not having any blood relation. A Muslim marriage takes place without fixation of dower. The marriage will be Shahi, that is valid, Fasid, that is irregular, Batil, that is void. It shall be void. The marriage takes place without fixation of dower, the marriage will be void. There should be fixation of the dower. Dower is in meher, which is an essential requisite of a valid marriage of the Muslim. So the marriage will be void. A Sunni Muslim husband marries his wife's sister. A Sunni Muslim husband marries his wife's sisters. The marriage is void, valid, voidable, or irregular. It is void. A Muslim man cannot marry his wife's sister. It is a void marriage. If a Muslim minor has been contracted in marriage in his minority by a guardian, such a person has a right of, on attaining majority, to repudiate the marriage. This is known in Muslim as talaq-i-tawfiz, talaq-ul-biddat, khiyal-ul-bulugh, or talaq-ul-sunnat. See, khiyal-ul-bulugh, this is the option of puberty. That is, if a Muslim minor has been contracted in marriage in his minority, on attaining majority, she may repudiate or the marriage. She or he may repudiate the marriage. This is known as the option of puberty. So this is khiyal bag, means the option of puberty. This is known in Muslim law as khiyal ul bulugh. The option of puberty is the correct answer. Which of the following is absolute incapacity for marriage? Consanguinity, affinity, fosterage. These all are incapacity, absolute incapacity for marriage. If a person is related by way of blood, you cannot marry. Affinity, you cannot marry. Fosterage, you cannot marry. So all of these are absolute incapacity for a marriage in Muslim, as per Muslim law. So all of the above is the correct answer. A marriage of a Muhammadian who is of sound mind and has attained puberty is brought about without his consent. The marriage will be valid, irregular, unlawful, or void. It is irregular. Who is of sound mind, has attained puberty, is brought about without his consent. That is irregular. A nikah is solemnized in the absence of qazi is valid, void, irregular, or none of the above. A nikah solemnized in the absence of qazi, it is valid. Why it is valid? Becomes valid if it is done in the presence of two or more witnesses. Qazi is not mandatory, but the marriage should be done with the presence of witness. So if there was witness, then the marriage is valid. A Muslim is prohibited to have two wives at a time if these two wives are related to each other by consanguinity, affinity, fosterage, or all of the above. If the wives are related to each other by way of blood, affinity, or fosterage. So all of the above is the correct answer. Here, wal buluk means option of puberty, as already covered. This means the option of puberty that gives the right to a minor girl or a boy after if they got married in the minority. After attaining majority, they can repudiate this marriage, and this is the option of puberty. A Shia Muslim husband emails divorce letter containing triple talaq. Divorce will be valid, void, voidable, or all of this. A Shia Muslim husband emails divorce letter containing triple talaq. Divorce will be void. Muta marriage is a concept in Hindu law, Muhammadan law, Contract Act, Special Marriage Act. It is Muhammadan law. This form of marriage is accepted in the Shia faction of Muslim. Sunni doesn't accept this. So this concept is available in the Muhammadan law. Minimum period for muta marriage is 1 month, 1 year, 3 months. No minimum period. No minimum period is there. This can be done for 1 day also. So minimum period for muta marriage is no minimum period is mentioned. Children of a sister and a brother can validly marry under which of the following laws? Christian law, Hindu law, Muslim law, or none of the above. It is under the Muslim law. Sister and a brother can validly marry under children of sister, brother, their children, and their children can validly marry under Muslim law only. Muslim male cannot marry wife's mother, son's wife, foster sister, all of this. Sister's wife's mother, affinity, son's wife, this is also affinity. Foster sister, this is fosterage. So Muslim male cannot marry all of the above. On the ground of fosterage, a Muslim marriage is void, valid, irregular, or muta. It is void. On the ground of fosterage, a Muslim marriage is void. During the term of muta marriage, the wife has a right to divorce. The husband has a right to divorce. Husband and wife both have a right to divorce. Neither the husband nor the wife has a right. See, during the muta marriage, neither the husband nor the wife has a right to divorce, because muta marriage is a contract for the purpose of enjoyment as per the Shia Muslim. So this marriage can be contracted for 1 day, 1 year, 1 month, whatever the time that is fixed as per the contract. So this form of marriage is not this is done for enjoyment only. So this doesn't form to be a permanent form of marriage. So neither the husband nor the wife has the right to divorce. If there is no marriage, there is no divorce. The funda is very simple: no marriage, no divorce. So in this case of muta marriage, neither the husband nor the wife has the right to divorce. This is the correct answer. Conversion of a Muslim wife to a faith other than Islam. Conversion of a Muslim wife to a faith other than Islam shall not by itself operate to dissolve her Muslim marriage. Shall by itself operate to dissolve her Muslim marriage. Gives a ground to husband to file a petition for dissolution of marriage, or gives a ground to the wife to file a petition for dissolution of marriage. Shall not by itself operate to dissolve her Muslim marriage. See, renunciation of Muslim of his religion is called apostasy. That is ridda, R-I-D-D-A, ridda, or apostasy. Apostasy by a husband, if the apostasy is done by the husband, then the marriage is dissolved at the instance. If the apostasy, that is the conversion, is done by a Muslim wife, by the wife, apostasy by the wife, the marriage is not dissolved, but Prior to the dissolution of Muslim Marriage Act 1939, this marriage would have been dissolved. This marriage would have been dissolved prior to the application of Dissolution of Muslim Marriage Act 1939. But as of now, this marriage is not dissolved. However, if the apostasy is done by the husband, the marriage gets dissolved. So, the conversion of a Muslim wife to a faith other than Islam shall not by itself operate to dissolve her Muslim marriage. But in case of husband, it shall by itself operate to dissolve the Muslim marriage. The answer is A. If Muslim wife, then it does not dissolve her marriage. But if husband, then it dissolves the Muslim marriage. A born Muslim girl brought up by a Hindu family married a Hindu boy as per such strict ceremonies. The marriage is a Muslim girl brought up by a Hindu family married a Hindu boy as per such strict ceremonies. The marriage is valid, invalid, voidable at the option of the girl, voidable at the option of the boy. It is an invalid marriage. A Hindu family, a Muslim girl brought up by a Hindu family married a Hindu boy as per such strict ceremonies. This is invalid because a Hindu cannot marry a Muslim, and a Muslim girl also cannot marry a non-Muslim, that is a Hindu. She cannot marry a Hindu boy. So this is an invalid marriage. Minimum period of muta marriage is 1 month, 1 year, 3 months. As already covered, there is no minimum period. Muta marriage is allowed in which of the following schools of Muslim law? Hanafi, Ismailis, Itna Ansari, Hanbali. See, these are all Sunni schools. Sunni schools. Hanafi, Ismailis, Hanbali. These are Sunni schools. And Sunni doesn't approve this form of marriage. So Itna Ansari is the only school of Itna Ansari is one of the schools of under Shia schools, Shia Muslim factions. So Itna Ansari, which belongs to the Sunni Shia group of Muslim, allow muta marriage. This is the Itna Ansari is the answer. Itna Ansari. Muta marriage is allowed in which of the following schools of Muslim law? That is Itna Ansari. Muta marriage is a concept in Hindu law, Muhammadian law, Contract Act, Special Marriage Act. It is Muhammadian law. And these marriages are accepted by Shia Muslims and not Sunni Muslims. If a Sunni Muslim marry with a Kitabiya girl, the marriage is valid, invalid, void, or irregular. See, if a Sunni Muslim marry with a Kitabiya girl, the marriage is valid, invalid, void, or irregular. It is valid. The Hanafi, that is the Sunni Muslim, or the Hanafi is a school of Sunni Muslim. Hanafi may marry a Kitabiya girl. Who are a Kitabiya girl? Kitabiya girl. Kitabiya girl can be a Christian, Jewish, or a fire worshipping woman. So Hanafi, that is the Sunni Muslims, can marry a Kitabiya girl. Who are the Kitabiya girls? They are Christian, Jewish, or fire worshipping women. So the marriage shall be a valid marriage. A Sunni marriage without witness is void, irregular, regular. None of this. It is irregular. It is a Sunni marriage without witness is irregular. A marriage between persons with consanguinity relationship under Muslim law is Shahi, that is valid, Fasid, that is irregular, or Batil, that is void. It is void. Marriage between persons with consanguinity, that is relationship by blood, with under Muslim law is void, Batil, that is void. A contract of marriage between A and B is made in joke and without any specific intention. Such marriage is valid under Hanafi law, Shia law, Shafi and Maliki law, or Hanabali law. That is, this is under Shia law. Joke and without any specific intention, such marriage is valid under Shia law. Marriage by a Muslim with his real sister is void, voidable, valid, or invalid. It is void. A Muslim cannot marry another person with whom there is a relationship by blood. So this is a void marriage. On consummation of a muta marriage, the wife is entitled to half dower, full dower, double dower, or no dower. See, in case of muta marriages, okay, we are talking about the muta marriages. If the marriage is consummated, the wife is entitled for the entire amount of dower. This is the consummation is there, then she will get the full amount. Okay. If no consummation has been done, if no consummation is there, then she is entitled, the wife is entitled for half dower. The wife is entitled for half dower. And if the wife leaves the husband before the period, before the expiration of the period, then the husband is entitled to deduct the dower proportionate to the number of days left. That is, as per this question is concerned, on consummation of a muta marriage, the wife is entitled to, will write the answer, that is the full dower. Consummation has been done, so she is entitled to the full dower. Answer is full dower. Muta marriage comes to an end by talaq, hibai muddat, talaqi tawfiz, none of the above. See, a muta marriage, this terminates by efflux of time or the expiration of the time or by death. The period of this marriage can be of any number of days, that may be 1 day, 1 month, or whatever period it is contracted for. On the expiry of the term, he may make a gift and terminate the contract with or without the consent of the wife, with or without the, even without the consent of the wife. So the muta marriage comes to an end either the expiration of the time, or he may make, that is the husband may make a gift and terminate the contract with or without the consent of the wife. That is hibai muddat is the correct answer. Hiba is, hiba matlab gift. Muta marriage comes to an end by hibai muddat. This is the correct answer. A marriage of a Muhammadian who is of sound mind and has attained property is brought about without his consent. The marriage will be irregular. The marriage will be irregular because soundness of mind is there and attained the puberty but without his consent. So shadi will be irregular. In Muslim law, payment of meher is necessary. Payment of meher, meher matlab dower. Dower is necessary. Payment of meher is not necessary. Meher is to be paid on demand before marriage. Meher is determined after marriage. No, payment of meher is necessary. It is a necessary condition. Meher is of, this dower is of two types. One is prompt meher, prompt, and the other one is deferred. Payment of meher is necessary. Either that is paid promptly or that is deferred. That depends upon. But the payment of meher is necessary as per Muslim law. So A is the correct answer. Which of the following is the wife's right when her husband does not pay dower? refuse consummation, file suit for recovery of dower, keep possession of a dead husband's property, all of the above. Wife's right. If her husband doesn't pay dower, she may refuse for consummation, file suit for the recovery of dower, or keep possession over the dead husband's property. All of the above is the right to the wife if the husband doesn't pay the dower. As regards the payment, the dower can be prompt, deferred, both A and B, only A and not B. It can be both A and B. Prompt dower, that is agreed instantly and paid as and when the wife claims for the payment, and deferred is the dower which is paid when there is a dissolution of marriage, either by way of divorce or by death. So both A and B is the correct answer. A Muslim marriage without dower is valid, void, irregular, voidable. It is void. Without dower, Muslim marriage is void. A dower debt is a secured debt, an actionable claim, a preferential debt, a mere right to sue. It is an actionable claim. A dower debt is an actionable claim. A marriage shall be, if the consent to a contract marriage is obtained by force or fraud, marriage shall be invalid. It shall be invalid if the consent to a contract marriage is obtained by force or by fraud. Thus, marriage will be invalid. The sub schools of Shia law are Itna Ansari school, Ismaili school, and Zaidi school, Shafi school, and Hanabali school. Both A and B above, neither A nor B. The sub schools of Shia laws are Itna Ansari school, Ismaili school, and Zaidi school. This is the correct answer. These are Sunni schools. Make incorrect statement. When any person converts to Islam, he is presumed to have renounced his earlier religion. It is correct. A conversion to Islam must be bona fide. It is also correct. A conversion to Islam may be made with the purpose of evading any unfavorable personal law. It should be wrong. Upon conversion to Islam, the convert is presumed to have substituted Islam in place of his earlier religion. It is correct. This option is not correct. A conversion to Islam may be made with the purpose of evading any unfavorable personal law is incorrect. In which of the following cases the Supreme Court has discussed the constitutional validity of triple talaq? Constitutional validity of triple talaq. The legal guardian of a Muslim minor family is father, grandfather, mother, or maternal uncle. The legal guardian of a Muslim minor family is the father. The legal guardian is the father, but the custodian is the mother. The legal guardian of a Muslim minor female is the father, but the custodian is the mother. Mother is entitled only to the custody of the person. She is not the legal guardian. So, mother is the right answer. Relative prohibitions to a Muslim marriage are: no Muslim can have a fifth wife, no marriage is valid if contracted without witnesses, no Muslim can marry a Hindu, all of the above. Relative prohibitions to a Muslim marriage are: no Muslim can have a fifth wife. Okay. No marriage is valid if contracted without witness. It is also correct. No Muslim can marry a Hindu, and all of the above. It is all of the above. Muslim can marry Christians, Jews, or fire worshippers, but they cannot marry a Hindu. So the relative prohibitions to a Muslim marriage are that no Muslim can have a fifth wife, that is up to fourth wife is permissible. No Muslim is valid. Marriage is valid if contracted without witness. Yes, it is also correct. No Muslim can marry a Hindu. It is also correct. So all the options are, all of the above are the relative prohibitions to a Muslim marriage. A Muslim man may have 4 wives at a time. Yes. Women can have only one husband at a time. It is also correct. So both A and B are correct. A Muslim man can marry or have 4 wives at a time, but a woman can have only one husband at a time. So both A and B are correct. A marriage contracted with is not valid. Ascendants like mother or grandmother and descendants like daughter, granddaughter. Relations of the second rank like brothers, sisters and their descendants, paternal and maternal uncles and aunts. These all are all of the above. A marriage contracted with the ascendants, relations of the second rank, paternal and maternal uncles and aunts is not valid. Marriage contracted with any of these, the marriage is not valid. Talaq ul biddat is complete and irrevocable divorce, incomplete and irrevocable divorce, complete and irrevocable divorce. None of the above. Talaq ul biddat is complete and irrevocable divorce. Once done, it is complete and it cannot be revoked. A Muslim goes to any country of the world with his personal law, without his personal law, leaving his personal law in the country, with an object of obeying the laws of the country concerned, which includes personal law. This is the correct answer. With an object of obeying the laws of the country concerned, which includes his personal law. In Muslim law, divorce by lien is a right available to the wife only, husband only, both husband and wife, neither husband nor wife. It is lien. It is lien. In Muslim law, divorce by lien, that is by mutual consent, mutual imprecation. This is a form of divorce of lien, that is mutual consent or the mutual imprecation. This form of divorce is both available to both husband and wife. Divorce by consent, mutual consent. This is available to both husband and wife. Lien means mutual imprecation or the mutual consent. Under the Muslim law, khula and mubarat are the forms of marriage, the forms of dissolution of marriage by agreement, the forms of repudiation of gift on attaining majority, the forms of demanding preemption. It is the forms of dissolution of marriage by agreement. This is the form of dissolution of marriage, khula and mubarat. These are the forms of dissolution of marriage by agreement. A talaq can be affected orally by spoken words in writing, only A and not B, either A or B. A talaq can be affected orally by spoken words or in writing. It is either A or B. The most proper divorce is Hasan talaq, Ihsan talaq, talaq ul sunnah, none of the above. It is the Hasan talaq. The most proper divorce is the Hasan talaq. Imprisonment of the husband is a ground for divorce under section 2(3) of the Dissolution of Muslim Marriage Act 1939. If the imprisonment is for a period of 7 years or more, 3 years or more, 10 years or more, or 4 years or more, it should be 7 years or more. If the husband is convicted for 7 years or more and confirmed by the highest appellate court, then the wife may claim for a divorce. the sentence must be confirmed by the highest appellate court. Then this becomes a ground for the wife for claiming divorce. A Muslim woman need to observe iddat in which of the following? Mutta marriage, irregular marriage, valid marriage. Muslim women need to observe iddat in any of the marriages. Either the marriage is muta, valid, irregular, any of the form of marriage, this iddat period is to be observed for remarrying. All of the above is the correct answer. And see, in case of mutta marriages, the iddat period is for 2 periods. Iddat period increases by 1 more periods. That is, iddat for 2 periods is to be observed. See, if iddat is the period that is to be observed by a Muslim woman before remarrying on divorce. See, in case of divorce, the iddat period is 3 months, and in case of dissolution of marriage by way of death of the husband, then the period is 4 months and 10 days. And in case of muta marriages, the period is 2 period, that is 3, that is the period is 6 months. The iddat period should be 6 months in case of muta marriage. So a Muslim woman need to observe iddat in which of the following? That is, muta marriage she is required, valid marriage she is required, irregular marriage she is required to observe in any form of any type of marriage. So answer is all of the. Which of the following is not a ground of divorce under the Special Marriage Act 1954? Adultery, cruelty, conversion, desertion. Which of the following is not a ground of divorce under the Special Marriage Act 1954? It is conversion. Conversion is not a ground under the Special Marriage Act 1954. A contract of marriage between A and B is made in joke and without any specific intention. Such marriage is valid under the Shia law. It is valid under Shia law, as this question is covered earlier also. Such marriage is valid under Shia law. Which of the following is a secondary source of Muslim law? Custom, ijama, qiyas, none of the above. Custom, this is the secondary source of Muslim law. Which of the following modifies the application of Muslim law? Muslim Marriage Dissolution Act 1939, Muslim Women Protection and Protection of Rights on Divorce Act 1986, Shariat Act, and all of the above. It is all of the. It is all of the above. After declaration of Waqf, the property becomes vested in God, Waqf, Mutawali, jointly on all of the above. It is the God. After declaration of Waqf, the property becomes vested in God. Mutawali is the manager of Waqf. Mutawali is the manager, but the property is vested on God. The marriage of a Muhammadian who is sound mind and has attained puberty is brought about without the consent of the marriage will be irregular. Already we have covered this question. This is irregular. A dower debt is a secured debt and actionable claim. It is an actionable claim. Already we have covered this. Which of the following is of the legal consequences of divorce under Muslim law? The parties acquire the right to contract another marriage. Yes. Cohabitation becomes unlawful. Yes. Mutual rights of inheritance ceases. Oh, of course. All of the above are correct. All of the above are correct. Legal consequences of divorce. The parties acquire the right to contract another marriage. A wife, after observing the iddat period, cohabitation becomes unlawful. Yes, they cannot enter into consummation. Mutual rights of inheritance ceases. Yes, it is correct. All of the above is the correct answer. When a Muslim mother loses her right of hijanat, that is custody of a child. A Muslim mother is the custodian of her minor child. But when does the mother loses her right of hijanat, that is the custody? By her apostasy, by her misconduct, by marrying within degree of prohibited relationship, or all of the above. By her apostasy, that is by converting to some other religion, that is by conversion, by her misconduct, or by marrying within degree of prohibited relations. All the options are correct. The Muslim mother loses her right of custody of a minor child by way of her apostasy, that is the conversion to some other religion, by her misconduct, or by marrying within degree of prohibited relationship. All of the above are correct answer. Tuhar means period of iddat, period of menstruation. Date of marriage, the period between the two menstruation cycle. Tuhar means the period between two menstrual cycles. For divorced women not subject to menstruation, the iddat period means lunar months after her divorce, that is 3 lunar months after her divorce. Where the wife is not pregnant, the period of iddat in case of death of husband is 3 months, 3 months and 10 days, 4 months and 10 days. In case of death of husband, the iddat period should be 4 months and 10 days. A Muslim woman can seek divorce if the husband is not traceable for a period of 7 years, 5 years, 4 years, or 3 years. It is for 4 years. If the husband is unheard of for 4 years, his wife may file a suit for a decree of divorce. And after this decree has been pronounced, this comes into effect or operation after 6 months, and the marriage gets dissolved. And if the husband within this 6 month of time presents himself and agrees to fulfill his marital responsibilities, the court may not dissolve the marriage. So the husband is not traceable for a period of 4 years, the wife may seek divorce. And after granting the divorce, the marriage is not dissolved outright, but there is a period of 6 months, and within this 6 months, if the husband comes and expresses that he will be fulfilling the marital responsibilities, then the court may not dissolve the marriage, but the woman can seek divorce if the husband is not traceable for a period of 4 years. 4 years is the correct answer. Failure of husband to provide for wife's maintenance is a ground for divorce under Section 2 of the Dissolution Marriage Act 1939. If the failure to maintain her is for a period of 3 years, 7 years, or 2 years, or 4 years, the period is for 2 years. There is a presumption of marriage when there is a prolonged and continuous cohabitation between the parties as husband and wife. A man acknowledges the paternity of a child born to the woman. Man acknowledges the woman as his wife. All of the above. All of the above is the correct answer. There is a presumption of marriage when there is a prolonged and continuous cohabitation between the parties as husband and wife. Yes. A man acknowledges the paternity of a child born to the woman. A man acknowledges the woman as his wife, and all of the above is the correct answer.